Hello LiveLaw viewers, welcome to Courts Today. Let us get to today's top legal updates. The Kerala Waqf Board has approached the Supreme Court opposing the Waqf Amendment Act, saying that it subverts secularism and violates fundamental rights. A court in Odisha has sentenced parents to life imprisonment who murdered and burned their minor daughter. The Jammu and Kashmir High Court has held that two adults choosing each other in marriage is a constitutional right and consent of family or clan is not necessary. The Supreme Court has said that for every instance of Section 498A IPC misuse, there are hundreds of genuine domestic cruelty cases. The Punjab and Haryana High Court has reduced sentence in a drugs case to time already undergone because the accused was the sole breadwinner of the family. And the MP High Court has upheld an order confirming 6-month detention for a 21-year-old accused of repeated drug trafficking despite bail. I am Urvashi Chauhan with your daily roundup of legal updates from across the country. For detailed reading, you can always visit www.livelawmedia.in. Please make sure to watch this video till the end and do not forget to like, share and subscribe to our channel. Well, before I get to the details, here is an exciting opportunity for the judiciary aspirants. LiveLaw Academy, LiveLaw's judiciary coaching initiative, has opened registrations for its May batch. You can choose from two tailored courses now. The first is Jessup 2.0, a comprehensive 18-month online program covering everything you need to crack the judiciary exam, taught by an expert panel including retired judges. And Jessup Light, a flexible, weekday-only program for those who prefer a structured yet lighter approach. Well, sign up today and get 25% early bird discount. Plus, enjoy free LiveLaw subscriptions, case compilations, and much more. Don't miss this opportunity. Enroll today at www.livelawacademy.in. The Kerala State Waqf Board has filed a preliminary affidavit before the Supreme Court challenging the constitutional validity of the Waqf Amendment Act 2025. In its reply, the board contended that the recent amendments subvert the principles of secularism and violate the fundamental rights of citizens and alleged that the central government was selectively targeting certain religions under the guise of reform. The board has accused the government of India of adopting a pick and choose policy by interfering only in the management of religious properties of certain communities. The Kerala Waqf Board has raised detailed objections to several provisions introduced through the 2025 amendments to the Waqf Act 1995. These include omission to the Waqf by user concept, mandatory 5-year Islamic practice requirement to create a Waqf, inclusion of non-Muslims in Waqf boards and the Central Waqf Council, transfer of adjudicatory powers from Waqf boards to government officials for property encroachment disputes, etc. The board emphasized that the inclusion of non-Muslims in Waqf institutions violates Article 26 of the Constitution, which guarantees every religious denomination the right to manage its own affairs. The board argues that non-Muslim members may lack the religious context needed to make decisions on Islamic endowments. The matter is currently being heard by the Supreme Court, which had on 17th April recorded the union government's undertaking not to act upon some of the contentious provisions of the amended act. The court had permitted state governments and Waqf boards to submit their responses. As you know, so far 7 states, namely Assam, Rajasthan, Chhattisgarh, Uttarakhand, Haryana, Gujarat and Maharashtra, have filed intervention applications supporting this 2025 amendment to the Waqf Act. In a disturbing case of honor killing, a sessions court in Odisha has sentenced a couple to life imprisonment for murdering their 15-year-old daughter, cremating her body and disposing of the ashes in a nearby river to destroy evidence. The additional sessions judge delivered the verdict while noting that although the case reflected grave nature of an honor killing, it did not fall under the rarest of rare category, warranting the death penalty. Let me tell you, the case here dates back to the night of 14th February 2016 when a co-villager lodged a report stating that she had heard the girl crying and pleading with her father to spare her life, promising to end her relationship with a man known to the family. Moments later, all went quiet. The following morning, the accused parents, with the assistance of some co-villagers, reportedly cremated a body in a dried pond behind their house. During the trial, the court recorded the statements of 30 prosecution witnesses. One of the first issues considered was whether the victim was a minor. The headmaster of the local school produced the girl's admission records, which listed her date of birth as 3rd October year 2000, confirming that she was just 15 years old at the time of her death. Most of the key witnesses, however, turned hostile, including the informant who denied having witnessed the incident and claimed that her thumb impression was taken on a blank sheet. Despite these setbacks, the prosecution was able to present compelling evidence through other witnesses. The court concluded that circumstantial evidence, along with the confessions and recovered materials, established the accused parents' guilt beyond reasonable doubt. Accordingly, the court found both parents guilty under sections 302 and 201 of IPC. A man who was accused of sexually assaulting the girl was, however, acquitted as the prosecution failed to establish the charges. Although the court recognized the act as honor killing, it refrained from awarding the death penalty. In his sentencing remarks, the judge said that such killings, while abhorrent, are not rare in today's society, and therefore the offense did not qualify as one of the rarest of rare to justify capital punishment. In the next update, reinforcing the constitutional values of liberty and individual autonomy, the High Court of Jammu and Kashmir and Ladakh has held that decision of two adults to marry each other is a protected right under the Constitution of India and does not require the approval of family, community, or any clan. Justice Wasim Sadiq Nargal, while hearing a protection plea filed by a married couple who feared for their safety, delivered a strongly worded order asserting that personal liberty and dignity are non-negotiable rights under Articles 19 and 21 of the Constitution. The court said that when two adults willingly choose to marry each other, it is their personal decision and no one can stop them based on societal constructs like caste, class, or family honor. The court made it clear that interference by family or community in such decisions constitutes a direct violation of fundamental rights. In light of the couple's apprehensions here, the court directed the concerned authorities to verify their age and the legality of their marriage under prevailing laws. If the verification confirms their claims, the authorities have been instructed to ensure the couple's safety and to proceed with any ongoing investigations without infringing upon their liberty. However, the court clarified that this order should not be treated as a certification of the validity of marriage or their age. These issues are to be verified separately in accordance with the law. The Supreme Court has upheld the constitutionality of Section 498A of the IPC, which is now Section 84 of the Bharatiya Nyaya Sanhita 2023, which deals with cruelty against women by their husbands or in-laws. The court made it clear that just because a law can be misused sometimes does not mean it should be struck down. While acknowledging that some misuse does happen, the court emphasized that for every false case, there are many genuine ones where this law has helped protect women from domestic abuse. It pointed out that dowry is still a harsh reality in many parts of India, and most cases go unreported because women are afraid or pressured to stay silent. In such a situation, the Section 498A remains necessary to safeguard their rights. The court rejected a PIL which had asked for balanced protection in matrimonial cases and safeguards against false complaints. The court said that making special laws for women is allowed under Article 15 of the Constitution, and such laws do not violate the right to equality under Article 14. Importantly, the court stressed that misuse of a law cannot be a reason to cancel it altogether. Instead, such issues should be handled individually and not become a reason to weaken legal protection for women. The court also said that it is not its job to interfere with the legislature's policy choices unless they clearly violate the Constitution, which the law here does not. Moving ahead, the Punjab and Haryana High Court recently showed leniency in a drug possession case by reducing the sentence of a 27-year-old man convicted under the NDPS Act. The man had originally been sentenced to 6 months of rigorous imprisonment and fined 5,000 for being found with 115 loose intoxicating tablets. However, considering that he was the first-time offender and no criminal background and was the sole breadwinner of his family, the court reduced his prison sentence to the period he had already spent in custody, which was about 2 months. Justice N.S. Shekhawat also acknowledged that the convict had been living abroad earlier for work and had faced a trial for more than 4 years. While the jail term was reduced, the court increased the fine to 1,05,000, directing that the 1 lakh of it must be deposited. Though the appellant did not challenge his conviction, his lawyer requested a lighter sentence. The court examined the case on merits and found that the police followed all legal procedures properly and the prosecution witnesses stood strong even under cross-examination. Therefore, the court dismissed the appeal against conviction but modified the sentence, ordering the immediate release of the appellant. And lastly, the Madhya Pradesh High Court has upheld the detention of a 21-year-old man who was found repeatedly involved in drug trafficking even after being released on bail. The court said that keeping him in detention for 6 months was necessary for the safety and welfare of the society. The man had earlier been booked in 4 criminal cases, 3 related to narcotic drugs and 1 under the Excise Act. After he got bail, he continued illegal drug activities. Based on this, the Commissioner of Indore passed a detention order under the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act, which the state government later confirmed. His lawyer argued that the Commissioner should not have fixed the detention period, saying only the state government had the power to do that. But the court clarified that even if the detention order mentioned 6 months, the final decision rests with the state government and the advisory board, which had reviewed the case and approved the detention. The court also cited past legal precedents and held that law allows detention for up to 12 months and that the 6-month period fixed here was well within its limits. Noting that the young man was a habitual offender who continued dealing in drugs even after getting bail, the court dismissed the petition. The court said that public safety was more important and the detention was justified.